Hello aspirants, welcome back to Believers IAS Academy, and as a part of Prelims high yielding topic discussion for the Prelims 2026, it is the part 3 of the emergency provisions chapter. Already we have discussed sufficiently with respect to almost 19 to 20 questions in the past two videos with respect to this chapter, and this video is going to be having another 5 more important concept which mostly revolves around the president rule and some other aspects with respect to president rule. Very, very important for the examination. So let's begin. So first question, during the national emergency, does parliament acquire exclusive authority to legislate on stateless subjects? And the second part says, is the situation similar during president rule, right? So first of all, we'll try and understand with respect to national emergency, which is Article 352, where under Article 353, subclause B, Parliament is the one which obtains that extra power or the special power to legislate on the state list subjects. And this power is not exclusive. Doesn't mean that only Parliament can legislate. That's what this sentence means. It means that the state legislature can also legislate, meaning which that the state legislature is not suspended. So hence Parliament does not have an exclusive power on legislating on the stateless subjects. Rather, state legislature also continues to exist and may also legislate on stateless matter. But however, there is a condition that if there is a conflict between parliamentary law and a state law, the parliamentary law which the parliament has enacted prevails. Okay, very important. Next is validity of such laws. So what happens to these kind of laws? So first and foremost thing is that the laws made by the parliament on stateless subjects, they remain effective, and especially during the emergency and also after the emergency, but only up until 6 months after the emergency ends, after which the parliament, the state legislature, can enact their own laws. Next is with respect to president rule. Very important dimension you have to keep in mind that the state legislature is usually suspended or dissolved. So hence, it is ultimately parliament who exercises the entire legislative power of the state legislature. And we can also say that the parliament legislates in place of the state legislature and not alongside it, as opposed to the situation in the national emergency. So if we have to see the key differences during the national emergency, it is the both parliament and the state legislature. However, it is not exclusively parliament. But on the other hand, during the president rule, parliament substitutes the state legislature, meaning which the state legislature either is dismissed or suspended. Okay, so moving on to the next question, who has the authority to revoke president's rule? Can parliament or the state legislature compel such revocation? Very important. So the president revokes president's rule by issuing a new proclamation. So he's the one who, let's say, invokes or proclaims a president's rule, and also he's the one who revokes it by issuing a new proclamation. However, this power is exercised on the advice of the Union Council of Ministers. So it is not himself or it is not the individual power of the president which he exercises by himself, but rather it is on the advice of the Union Council of Ministers. And in terms of the parliament, parliament cannot directly revoke the president's rule, but the proclamation on continuing the president rule, if that is disapproved by the parliament, then automatically the president rule lapses. So that is also one important thing to keep in mind. And in terms of state legislature, they cannot pass any resolution demanding revocation. Why? Because ultimately the state legislature or the government, the local government at the state level is either dissolved or suspended during the president rule. So the power of revocation exclusively lies with the president. And if the parliament also in that matter for the continuation of the president rule, if it disapproves, right, or if it refuses to approve its extension, then the president rule automatically lapses. Next question, which constitutional expert described Article 356 as a dead letter? Very important. It was Mr. Dr. B.R. Ambedkar who expressed or who said that president rule is like a dead letter of the constitution. And why did he say it? Because he expected that the president rule ought to be used very rarely and very sparsely. However, according to him, it should be applied only in exceptional circumstances. And if used improperly, it would undermine the federalism, is also what was told by Dr. B.R. Ambedkar. But ironically, we have seen that many instances have happened. In fact, more than 50 to 70 precedent rules have been imposed so far. And Article 356 is an irony to what the drafting committee members, or let's say the famous personality, Mr. Dr. B.R. Ambedkar, had thought about this particular precedent rule, which is not in reality what it is or what it was supposed to be. So it was frequently used in the early decades after independence. Very recent example is your Manipur. Okay. Next question. What is the constitutional significance of S.R. Bommai judgment regarding the President's rule? So it is a very important judgment. So S.R. Bommai versus the Union of Judgment. This is a landmark judgment which transformed the interpretation of the President rule or the Article 356. So there were few important major principles which were established or which were implemented after the SR Bommai case. First is the with respect to judicial review. Next is with respect to flow test principles, secularism as a basic structure, assembly dissolution safeguard, and also restoration power. So what is the judicial review? So it made the proclamation of President rule under the purview of the judiciary, or it made President rule subject to judicial review. That now courts can examine whether the proclamation of President rule or imposing President rule over a particular state is justifiable or not, or is it based on any relevant material. And next is it brought in floor test principle, where it says that majority of state government should be tested on the floor of the assembly and not merely on the decision given by the governor, or not merely by the report which governor presents to the president stating that it is necessary for this particular state to be under the president rule, right? So the majority of state government on the floor made it, it was made mandatory, right? It was made compulsory to decide the condition and not just merely on the advice of the governor. Next is secularism was made a basic structure, right? Because if the state government acts against any secular principles, then that can become an active reason and a major reason why precedent rule can be invoked and it can be justified as well. Next is in terms of assembly dissolution safeguard. The legislative assembly, which usually gets either gets dismissed or suspended, the SR Bommai case made it clear or clarified that it cannot be dissolved before parliamentary approval of president rule. So usually the president rule proclamation after the verdict, or let's say after the proposal has gone to the president, it is sent to the parliament and 2 months is given within which the proclamation has to be passed by the parliament as well, right? Even they should also accept it. And until the parliament approves that particular proclamation of president rule, the legislative assembly of that concerned state does not get dissolved, as what the safeguard that SR Bommai case brought in. Next is in terms of the restoration power. If the court finds the proclamation unconstitutional, because we also talked about the courts having a judicial review, like let's say this is under the purview of judicial review. So now if the courts decide that the proclamation was unconstitutional, it can also restore the dismissed state government as well, right? So that is also one important aspect. Now we'll also see the situations where Article 356 may be properly used. There are a few important situations. So these are the situations where precedent rule can be justified. First is breakdown of constitutional machinery. Second is loss of majority proven in assembly, talking about the floor majority. And then third is the failure of state government to follow the constitutional provisions. And fourth important is anti-constitutional activities. Example is undermining the secular feature or secularism. Next, there are three important aspects where imposing precedent rule can be improper. First is the political disagreements between the center and state doesn't essentially mean that now that particular state has to be put under the watch of the center or put under the precedent rule. Second is the dismissal of government despite a majority support. This is also not a valid reason. Third is using Article 356 for partisan political advantage. So for any political advantages or any political means, it shouldn't be used as a tool, is what that point refers to. Next question, what are the grounds for declaring a financial emergency? Explain the parliamentary approval process and duration. This is also very important. So financial emergency is declared under Article 360, and keep in mind, so far in India, not even a single financial emergency has ever occurred. Anyway, talking about the grounds of the proclamation, it can be or may be proclaimed if the president is satisfied based on two conditions: that the financial stability of the country is not proper, and second is the credit of India or any part of its territory is under trouble. So these are the two important reasons, and if these two reasons satisfied, or let's say these two conditions get satisfied, that's when the president can proclaim the financial emergency. And in terms of parliamentary approval, it is similar to the president rule. The parliament proclamation, it must be approved by both the houses within 2 months, and if that particular point of time Lok Sabha is dissolved, Rajya Sabha can approve it, and after the freshly convened Lok Sabha session is called, it must approve within 30 days of its first sitting after reconstitution. And in terms of duration, once it is approved, the financial emergency continues until it is revoked by the president. This is also very important feature of the financial emergency. Next is, does financial emergency contain a sunset clause? Is parliamentary approval required? So now what is the sunset clause? We will see. So basically, it does not. The financial emergency has no sunset clause, meaning which no maximum time limit exists for financial emergency, means it is not co-terminus, right, to some extent. However, it may continue indefinitely until revoked by the president himself, right? So that is what the sunset clauses means. There is no sunset, right? It is like completely continuously on and on unless and until the president feels that we have to revoke it. Next is, in terms of the parliamentary approval, parliament approval is mandatory within 2 months. I mean to say both the Rajya Sabha and the Lok Sabha as well. And after the approval, no periodic renewal is also required, pretty much like your national emergency or even your president rule. Next, in terms of the powers exercised during financial emergency, there are few important powers of center. First one is, it can direct states to observe financial discipline. Second is, it can reduce the salaries of state employees, reduce salaries of judges of the Supreme Court and the High Court, and also require that state money bills be reserved for presidential consideration to make sure that the state is also spending, or state is also going frugal in terms of the fiscal spending that it is doing. And that is all with respect to the financial emergency and the president rule. I hope this pretty much covers the entire chapter, very important chapter, and also that chapter which has more of concepts within, embedded within it. And a lot of confusions can happen if the concepts are not clear, especially we're talking about three important emergencies. So I hope this is clear. Anyway, we'll continue the series and probably do more better videos on some of the important chapters which are still remaining. So until then, stay tuned. Please subscribe to Believers IAS YouTube channel. And signing off, this is Madan Gopal. Have a beautiful day.